Good evening, everyone. Welcome. This is the Town of Somers Zoning Board of Appeals meeting. The date is April 18th, 2023. Denise, would you please take the roll?
Ms. DiPolito?
Here.
Mr. Gio?
Here.
Mr. Hardin?
Here.
Mr. Lansky?
Here.
Mr. Newman?
Here.
Chairman Canestra?
Here.
Thank
I ask
you.
everyone to stand for the Pledge of Allegiance. I pledge allegiance to the flag
Flag
of the United States of America,
to the republic for which it stands,
one
a nation, under God, indivisible, with liberty and justice for all. Carol, I'm going to mute you.
Okay, thank you, everyone. As you can see, this is a in-person public meeting, and we also have individuals online. And the public can attend, of course, in person, or can call in on the Zoom lines, phone numbers, which we'll provide if someone wants to comment on any of the items on the agenda this evening. So we're going to go right into the agenda. First item we have this evening is that of Eileen Ullman. This is an application to renew a special exception use permit for an existing accessory apartment attached to an existing one-family dwelling in an R80 residential district at 28 Francis Drive, Petona. Is Ms. Ullman available? Oh, okay. Hello, how are you? Good. Could you just come up to the microphone and just give us your name and address?
My name is Eileen Ullman. We are at 28 Francis Drive in Somers.
Okay. And you have an existing accessory apartment and you're looking to renew it?
Yes.
Okay. Okay. I just want to look over our stat sheet just for a moment here. The building inspector has been out to inspect the apartment? Okay, and it's in compliance with everything that you have listed here?
It is.
Okay, thank you. Ms. Ullman, how many people live in the apartment right now?
Me, one.
Just one.
One.
Oh, you live in the apartment?
Yes, this arrangement has been for many years, and my parents originally were in it. Then as my husband and I aged, we were in it, and my husband died, so I'm the sole occupant, and my daughter is now in the other house.
In the main house? Okay,
Yeah.
I see. I see. I assume the building department doesn't have any complaints regarding this apartment, disturbances or other issues?
No. Yeah, sorry. Go ahead, Tom.
Okay.
No complaint.
No complaints. Okay.
How's the landlord?
So far, okay.
Let us know.
Okay. 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 Any additional questions of the applicant at this point in time?
Is it, sorry, this is one structure, or there are two, is it two separate,
No, it's one structure,
one structure?
side by side.
Any further questions of the applicant or any discussions the board would like to have in regard to this issue?
I do have one question for Tommy, because he would more so. What is the square footage of the apartment, approximately?
I had to measure it up. There was nothing indicating the square footage on file or in any of the past zoning board
Can you speak into the mic?
resolutions. How's that? Better? I calculated at approximately 864 square feet.
Thank you.
So slightly over the 800.
Yeah.
That's allowed per the code, but okay. But this is a renewal, so this apartment has been previously approved
Yeah, there is.
With no record of this.
Many times.
with no
Right.
record of the square footage. Yeah.
So what did we decide there? Are we going to do a variance?
We could, if the applicant asks for.
Oh, right, they have to
variance,
apply.
Then it would run with the land, right? And we wouldn't, this issue wouldn't be raised again, that the 864 square feet is not in compliance with the code.
Right.
But if the applicant doesn't ask for that, we are we may renew this
Yep.
permit as it stands.
Got it.
It's better for applicant to not have to deal with the square footage issue again. But it would not, it should be noticed to some regard in general, so. My thought would be we continue with this.
Vote on it as is because
Right.
they haven't requested a variance and whether we want to approve it or not, right?
No, I agree.
Okay. Maybe we should put this out to the public as the next step here. Does anybody wish to speak in regard to this application, whether in person or online? Okay, and if we could open up online to phone calls to see if anybody wants to call in to comment in regard to this application. I'm speaking specifically to our video man in the back. Can you open this up to the public with the phone numbers?
Yes.
Thank you. So anyone can call in on any of the numbers, just punch in the Zoom meeting ID number and it'll bring you on. So if you have any questions or comments regarding this application, we'll be willing to hear it. We'll just leave it up for a half a minute, see if anybody wants to speak. Any further comments from the board while we're waiting? Discussion points?
Nothing.
No, I'm good.
Yeah, this is in an R80 district, so minimum 80,000 square feet, and actually they're above that, they're 2.5 acres, so I think actually, you know, the extra size of the property, I think also helps.
Yeah.
So. Okay, it doesn't look like we have anybody who wants to comment in regard to this application. Ma'am, do you have any further comments or anything else you'd like to say in regard to the application?
No, and this has been standing and approved about 7 times. That's, I think, I have this high. I decided not to bring it, my records of each time.
Okay,
So
I
that's why I said-
understand it. Doesn't seem to be any complaints or problems with noise or parties or anything like that, so I think we're okay. Okay, can we have a motion as to the type of action?
I'll make a motion type 2. I second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye.
Thank you.
We have a motion whether we're going to grant the 7-year special exception use permit for an accessory apartment.
I move we grant the 7-year exception.
Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Congratulations,
Thank you
your
very much.
application has been granted.
Thank you.
Have a good evening. We're going to go to the second item on the agenda this evening. This is the application of William and Mariana Breglio. This is an application to renew a special exception use permit for an existing accessory apartment in the basement of an existing one-family dwelling in an R40 residential district at 11 Franklin Drive, Mayapack. Is someone here to represent the applicant?
I am.
Okay, sir, could you just give us your name and address?
Sure. My name is William Breglio. My address is 11 Franklin Drive, Mayapack, New York, 10541.
Okay. And has the building inspector been out to inspect this apartment?
I have.
Okay, and everything is in compliance with what has been indicated on our stat sheet here.
That's correct.
Okay. And sir, how many people occupy the apartment?
No one. It's my personal office at this point, and a lot of Lego and Nerf guns.
So you want to just have it available in case you do decide to lease the apartment out?
Correct. We honestly like the second kitchen. That's to be honest with you, just for family parties and stuff like that.
Okay, okay. I assume there haven't been any complaints with the neighbors regarding this apartment?
There have
None that I've heard of.
Okay, good. This apartment is 657 square feet, so it's certainly below the 800 limit. Okay. Any further questions from board members? Any comments?
I have none.
Good.
Okay. Why don't we open this up to the public? Is anybody here or online wish to speak in regard to this application? If we could just put up our Zoom numbers once again. Anybody wishing to comment in regard to this application can please call in, and we're happy to hear any comments that you might have. Any further comments from the board? Everyone good? Yes. Okay. All right, doesn't look like anyone is commenting in regard to this application. Mr. Breglio, do you have any further comments?
None at this time. Thank you.
Nope.
Only thank you to the board and thank you to Denise and Tom for their help with this process.
Okay. All right. Do we have a motion as to the type of action?
Motion type 2.
Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Can we have a
Thank you.
motion? Can we have a motion whether we're going to grant the 7-year special exception use permit for an accessory apartment?
I move we grant the 7-year exception. Thank you.
Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Congratulations, sir. Your application has been granted.
Thank you all.
Have a good night.
You too.
Okay, we're going on to the third item on the agenda this evening. This is the application of Louis, excuse the last name, Ekreb. Okay, I'm sorry. This is an application to renew a special exception use permit for an existing accessory apartment on the second floor of a detached accessory building. Of a detached accessory of an existing one-family dwelling in an R120 residential district at 99 Mosman Avenue, Katona. Is someone here to represent the applicant?
Yes, this is Louis Ekareb online. I reside at 99 Mosman Avenue, Katona, New York, 10536. I'm applying for an accessory apartment on top of a existing garage. It's a 2-bedroom, 2-bathroom plus a den apartment. It's about 1,600 square feet, I think. Currently, there is a tenant in there, a young couple by themselves. The property on the whole is relatively private. I'm not aware of any complaints ever from them, for them.
Okay. I'm looking at this application right now. Thing that stands out at me is that the accessory apartment, it's listed on this application at 1,200 square feet. You think it's 1,600 square feet?
No, not really. I'm sort of guessing it. I don't have the diagrams, the drawings in front of me.
Did you make a determination of 1,200, Tom?
I took those dimensions off of the architectural drawings I have on file.
Okay.
Okay. So this is,
Have you been out to visit
I have.
and the drawings match?
They do.
and this has been approved in the past. This does list as a renewal.
That's correct. I think it's been since the 90s. It's been an apartment for a couple.
Yeah, it has listed renewal dates 93, 2003, 2011. So it's a little beyond
And then it's 2016.
Oh, it's 2016, right? Okay, I can see that.
I assume that's when you purchased it, 2016?
Yeah, so the property, I've been an owner of the property in one way or another for a long time through a trust, but I've owned it outright since 2016. The current tenant, I think, has been there since 2020 or 2021 or so.
Now, I will say, Mr. Ackrat, my name is Arnie Gio. I grew up on South Lane. In the ways we were neighbors, I am familiar with the parcel of land that you do own. And I know you took occupancy, actually, your parents took occupancy when the mansion burnt down. And they took occupancy to stay there while the mansion was being built.
You're talking about the accessory apartment?
Yes, over the garage. This is over the garage, correct?
Yes, but I don't think that's exactly correct. If you're referring to the family staying on the property while the new house was being built, that actually was right. So that was a different structure, also a garage with a studio room attached. And that's where the family spent 3 years alternating between members of the family while the new house was being built.
So we have 1,200 square feet, 2 bedrooms.
The timeline is off a little bit. The house burned, the main house burned in the early 80s. And the accessory apartment above the garage that I'm applying for now was built and granted in 93, as you indicated. So we're talking about 2 different structures.
Okay.
Okay, so the issue here, I think that I see is obviously this existing apartment is 50% over the limit of an 800 square foot apartment. Per the code, Tom, can accessory apartments have 2 bedrooms? Are they supposed to have 1?
They can have a second bedroom if the zoning board feels it does not overburden the property. This building has a separate septic system that was approved by Westchester County Board of Health.
And I do see it's on 16, almost 16 and a half acres here.
That's correct.
Okay. What does the board think of the size of the apartment?
I feel it's a little overwhelming, but since it's been granted so many times, plus the fact that the location, that it is on 16 acres and it's backed up with county land, and there is not a residence to be seen in any particular area.
What's the size of the house?
Big.
Sir, can you give us the square footage of the house?
Of the main house?
Yeah.
About 9,500 square feet.
So sometimes an apartment, if a house is only 2,000 square feet, and you have an accessory apartment above 800 square feet, it's no longer really accessory. But on a 10,000 square foot house, a 1,200 square foot apartment still feels like an accessory use. That was the nature of that question.
I know the apartment well, and I agree with Arnie. It is an accessory apartment on the property.
Just to add a little bit of history here, it was originally designed for a caretaker to live on the property, which was a request made by the insurance company. This is from my previous owner. And that's how it's currently being used. It's not necessarily exclusively for generating income. It's a mutual agreement between the tenant and myself to have someone on the property.
I think certainly the size of the property helps mitigate the size of the apartment and the size of the building, so.
I agree.
That plus the separate septic.
And the separate septic
The
also,
Property can
Yeah.
handle this.
obviously, yeah, that's good.
And the lack of neighbors and the fact that it's been already approved a significant number of times.
Right.
All trend towards. My opinion being in favor.
Right. Okay.
I agree.
Same here.
All right, let's take this out to the public and we'll see if anybody would like to speak, whether you're here or online in regard to this application. Once again, we're putting our phone numbers up on the screen. Anybody who has any comments or questions can certainly call in. Any further discussion the board would like to have in regard to this? Any comments? Anything more? Yeah, at first, the size of this apartment gave me some pause, but you know, talking this out, I think with its size and I think gives me a little bit more comfort.
So I think the language from the code, just to read it in, is. Each accessory apartment shall contain not more than one bedroom unless, in the opinion of the ZBA, a second bedroom can be adequately accommodated within the existing building and will not overburden the property. And the building was issued a certificate of occupancy prior to April 1st, 1992. So I think all those conditions are met.
Yeah, C of O was in 1984 here.
So
Yeah,
I'm in favor of the second bedroom. And the only thing outside then of the code is the 800 square foot size, which I think. I'm also in favor of.
Okay. All right, we're going to close down public comment in regard to this application. Sir, do you have any further comments or anything else you'd like to say in regard to your application before we vote?
The apartment size, I think, was dictated simply by the existing 4-car garage that it resides on top of. That's all I can say to that.
Okay.
I wasn't the owner when it was built.
Okay. You have a motion in regard to this application?
Motion type 2.
Second.
Ms. DiPolito,
Hi.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Can we have a motion as to whether we're going to grant the 7-year special exception use permit for the accessory apartment?
I'll make a motion to grant the renewal of a special exception use permit for 7 years for the sale of the property, whichever.
I'll second.
Ms. DiPolito,
Hi.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Congratulations, sir. Your application has been granted.
Thank you very much to everyone.
Have a good evening.
Thank you.
Bye.
We are going to go to item 4 on the agenda this evening. This is the applicant is Carol Minaw. This is an application to renew a special exception use permit for an existing accessory apartment in the basement of an existing 1-family dwelling in an R10 residential district at 23 Lakeview Terrace, Amawalk. Is there someone here to represent the applicant?
Oh, wait.
I got it. Yes.
Okay. Could you give us your name and address, please?
Carol Mina, 23 Lakeview Terrace, Amawalk, New York.
Okay, thank you. And you're renewing a special exception use permit. How many people are currently occupying the apartment?
One, my mom.
Okay. And Tom, have you been out there to inspect the apartment?
I have.
Okay. And everything is in compliance with what you've indicated here on our information sheet?
It matches the drawings
It does.
we have on file, yes.
Okay. Have there been any complaints or other issues regarding this apartment?
Nothing,
Okay.
no.
Okay. I do notice the square footage of the apartment is 875 square feet, slightly over the 800 limit. Okay. Okay.
We're also in an R10.
Yeah, we're on a
Small lot.
on a smaller property here, right? This is an R10 or 10,000 square foot residential district.
And again with prior approval.
Right, there's prior
Right.
approval here. I do see that. And the building was built in 1974, so before 1992. Okay. Does the applicant have anything they'd like to say in regard to this application?
No, we were first approved in 2008 when my parents moved in. Since then, my dad passed away, so it's just my mom downstairs.
Okay. Any questions from board members? Any further comments in regard to it?
I'm good.
No. Okay, I'm going to open this up to public discussion. Anybody here or online wishes to speak in regard to this application? Now is your opportunity. All right, leave this open just another few seconds. Okay, no last chance. No one wishes to speak in regard to the application? Nope. Okay. We'll close the public hearing then on this and prepare to take a vote. Any further comments from board members? Last chance? Nope.
I'm good.
Can I have a motion as to the type of action?
Type 2. Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. We have a motion whether we're going to grant the renewal of the 7-year special exception use permit.
I make a motion to grant the renewal of the special exception use permit for 7 years or to the sale of the property, whichever occurs first.
Second.
I'm sorry, I didn't hear second. Who's second?
All
Is
right.
that you, Bill?
Arnie.
Okay, thank you, Arnie.
You're welcome.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye.
Thank you.
Congratulations, your application has been granted.
Thank you.
Have a good evening.
You too.
All right, this is a big night for special exception use permits. Okay.
We
Fifth
have
item
2
on the
left.
agenda. Okay. All right, fifth item on the agenda this evening, that of Albert Totten. This is an application to renew a special exception use permit for an existing accessory apartment in the basement of an existing one-family dwelling in an R40 residential district at 47 Stonehouse Road, Somers. Is someone here to represent the applicant? Denise,
Is
you
he
don't
not-
have any,
Oh, I thought I saw him walk in the door. Okay, I
no
will.
one's here.
Okay, I'll reach out to him and I'll carry that over to May.
Okay.
Okay.
We'll make note this is going to be a carryover. Okay. Well, that brings us to item number 6 on the agenda, that of John and Elizabeth Leary. This is an application for proposed alterations to an existing accessory apartment in a detached accessory to an existing one-family dwelling in an R80 residential district at 108 Pines Bridge Road, Katona. And I know we do have some plans that go along with this application also. Sir, if you could please give us your name and how you represent the applicant?
Sure. My name is John Leary. I am the applicant, and we reside at 108 Pines Bridge Road, Katona.
Can you describe for us what you'd like to do to the existing accessory apartment?
Sure. So we have an accessory building on the property. All of it dates to, we believe, like the 1880s. It's been an accessory apartment. This building has been an accessory apartment for some time. I've renewed it twice in front of the board. We've finally found a really good use for it. My mother-in-law is now a widow, and we're looking at kind of the long-term living arrangements for her. So we thought this is ideal for her to move into. However, we need her for health reasons and physical movement reasons. We need her to be on a single floor living. So we're trying to reconfigure the space so that we can have, a single floor, floor plan instead of a two-story, which the existing building is.
We have a series of plans before us, and maybe it's a little confusing as to the plans, as to what's happening here,
I'm sure
how things are changing.
I'm sure that's a lot to digest.
Yeah, it's a lot going on here.
Yeah, imagination runs. But to put simply, we have an existing storage room or one-car garage. It's actually, we never use it as a garage because it's for practical purposes, it's quite small.
And on which plan would this be? There's A1, A2, and A3. Which one should we be looking at?
So if you look at A1, they all give the perimeter of the building the same. But if you look at A1, in the lower part of the plans, the space on the far right is the existing garage or storage area.
Okay.
And what we'd like to do is simply convert that to, put a bedroom and an ensuite bath in there.
Can I ask, how long has this been an apartment?
It was an apartment when we moved in 2007. That was my first appearance here to renew the permit when we took ownership of the house.
But it hasn't been an apartment since the 1880s.
It has not been. So the prior owner at some point, like I said, when we bought the apartment, I came in per code to renew it because it changed ownership.
So this has been previously approved in our records. Tom, are you aware that this has this particular one been approved?
What was the date of your last renewal?
We were just here in November, I believe.
Yeah,
to renew it.
Fairly recent.
Okay.
November of 2022, correct?
November of 2022, correct.
And the apartment was located where when it was originally renewed? It wasn't in the garage here, right?
It was not.
Where was the apartment before?
Well, the first story is one space, and upstairs there are two rooms and two bathrooms. And so I believe the way it was originally permitted was one of those rooms was an office, one was a bedroom, and then the kitchen and living space was downstairs. So we're maintaining kitchen and living space downstairs, but we need to give her a place to sleep downstairs.
And what's the plan for upstairs? Are you just?
I work full-time out of the upstairs, so I maintain an office, and my wife is an artist, and she has an art studio up there. As part of the plan, we're adding an exterior entrance to the second floor directly so that we can continue to use that space for our use, independent of the living space downstairs.
So the second floor will not be part of the accessory apartment. That will be used by you and your spouse for work or whatever.
That's correct.
And it'll just be the first floor, including the garage.
That's correct.
That you're going to renovate.
That's correct.
That new space on the first floor, including the garage, how many square feet will that be?
I mean, by my measurement off the architect's plans, it's about 740 square feet. And Tom, I don't know if you measured it out, but
I didn't. I thought it was on the drawings somewhere.
You can check my math if you like, but I have it as let me just check. Yeah, 742 square feet. It's about the dimensions of the main living space are 34 by 16, and the converted space, the space we want to convert to the bedroom, is 18 by 11.
So architectural plan A1 bottom left-hand corner, that shows the space. Is that space this, because I'm looking at other pages, but that must be other parts of the house or second floor?
Yeah, we're doing a couple of things. We're moving the stairs. So there's a lot of stuff on this plan that's more aesthetic. But if you look at, A1 is listed as the demolition plan, but that shows the existing space. And we're not adding to the perimeter of the building at all. We're just taking that storage garage space and turning it into a bedroom.
It says it's a deck in the demolition plan.
On the second floor, if you look at A3,
Okay.
you can get a better sense of the structure.
So it's a deck above that garage.
Oh, okay.
So there's an exterior deck upstairs, and that's where we're contemplating or propose to put an exterior stairwell up so I can get in and out of my office off that deck directly.
So A1 is really the second floor. This is partial demolition and second floor demolition plan.
A1 shows,
All right, it's saying second floor demolition plan. And it seems to.
well, if you look at the very bottom of the page, there's a second floor
first
demolition
floor.
in the middle, and the very bottom image is the first floor.
Oh, I see. Now I got it.
So as previously approved, the apartment is both floors,
That's correct.
Which I assume is larger than the new proposed single floor accessory apartment.
That's correct.
Do you happen to recall what the square footage on the previous was?
I don't know if it's in the record or not.
But if one floor is 740 and you're 1 floor plus 3/4 of another one, you're probably around 1,300 square feet.
Yeah, I don't even think it makes up 3/4 of the second floor. Maybe 50%, would you
Maybe,
say?
yeah, it's hard to,
If you take the deck out, I guess maybe that.
yeah,
would be
you
part-
subtract the
okay.
deck.
Yeah.
So certainly you're downsizing the accessory apartment
That's correct.
to something that's beneath the 800 square feet, where currently you're over 800 square feet.
That's
So-
correct.
So I think that's that's attractive to me and because, we're more in compliance with the code.
Yeah, that was our thought. It's also self-contained now. It can truly be used exclusively as an apartment, and then other spaces, my office, etc.
There'll still be an interior staircase, though, access to second floor, first and second.
There will be, but the plans call for a lockable door, and whatever's required by code, the ceiling sheetrock and such.
Right. And the first floor accessory apartment will have egress outside, obviously.
There's an existing front door, and we're adding a back door as well.
Okay, so there's two means of egress and then the stairs, but that could be locked, then you need a second egress.
Yep.
Okay. Okay. Now you're in an R80 residential district. How big is your lot?
It's about 10 1/3 acres.
Okay. So well over. Okay. And how big is the main house?
I mean, I'd be estimating, but 2,600 square feet.
The septic for this accessory apartment, does this tie into the main house's septic?
Yes.
Okay. The new apartment as constructed will be 1 bedroom,
That's correct.
obviously with a kitchen and a bath. Going to be a laundry room on the first floor, it looks like too?
It's already a laundry room,
Okay.
and the kitchen is in place currently.
Like you said, you're converting the garage to living space, so it'll have to be insulated and whatever you got to do to
Yeah, that's right. All
the required, right? Okay.
Yeah, it's really about mobility. It's not practical for her to go up and down the stairs.
Yeah, makes sense.
Everything seems to be.
Looks good to me.
Yeah, any other? Yeah. Okay. All right, maybe what we should do is we should open it up to the public. Anyone here or online wishes to comment in regard to this application? Now is the time to do so. Once again, we'll put our numbers up on screen. Anybody have any comments from the audience here? All right, we'll just give it a half a minute here, see if anybody wishes to speak. When are you expecting to do this work?
Right away. She needs to, we have the plans drawn, so we hope to start soon.
Got good weather before the winter comes in.
Exactly.
So are we granting a new special exception use permit for this space for 7 years? Or are we just allowing the
Because this
alteration?
is not really a renewal in my mind. This is a new apartment, right?
Well,
Reconfiguration.
Yeah,
Alteration.
but what category does it fall under?
It's a new special exception use permit.
Yeah.
That would serve applicant's purposes. He gets a clean 7 years. It's a new plan, it's a new space.
you agree, Tom?
I do.
Okay. Okay, doesn't seem like we have anybody who wants to comment in regard to this application. Any further comments or questions from the board? Sir, as the applicant, you have anything further you'd like to say?
No.
Okay. I think we're probably prepared to vote. Okay, can we have a motion as the type of action?
Make a motion type 2.
Second.
Ms. DiPolito?
Aye.
I'm sorry, Mr. Gio,
Aye.
Mr. Hardin,
There.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Do we have a motion whether we're going to, if we're going to grant a 7-year special exception use permit for basically a new accessory apartment?
I'll make a motion to approve a special exception use permit for a renovated 1-story accessory apartment at 108 Pines Bridge Road.
I'll second that.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Congratulations, sir. Your application has been granted.
Thanks very much to the board. Thank you very much. And Denise and Tom, thank you as well.
Thank you.
Thank you.
Okay, we're going to go to item 7 on the agenda this evening. This is a carryover application of Victor and Deborah Wu. This is an application for a side yard area variance for an existing in-ground pool accessory in an R80 residential district at 8 Silver Springs Court, Katona. Mr. Caruso, would you like to start?
Thank you, Mr. Chairman. If the board would like, I can go through our most recent submission or answer questions directly, whatever the board pleases.
We are in receipt of your most recent submission, and one of the significant matters before the board is whether the application is timely. Is that an issue we should address first, or should we let Mr. Caruso? Maybe we should let Mr. Caruso.
Well, but has everyone read?
Well, I don't think we,
Submission?
I mean, I think we've probably read it, but I think a summary would be good from both sides before we, make any kind of decision on what we're going to do.
So we're gonna do them individually. Right, so whether it's timely,
Right, I think we have to, right, we're first going to make a decision, whether the application is time barred, not allowed, or whether it is timely and we're going to hear it.
okay, so then we'll do
We should,
1 and 1, and then if we move forward, we'll do it again, 1 and 1, versus having them address all 3.
right, I think they should address the timeliness issue, whether the application is properly before us. Would everybody agree that that's the first issue? Right, because if we feel it's not properly before us, then, it's a moot point to proceed further. So, okay,
All right,
Sure.
so I'll take it from the top, so to speak.
okay.
We touched on some of the issues at the prior meeting, but let me just break it down into the most clear components. I think the board has really two questions, if you will. Number one, is there a duplication of applications, right? And number two, is the current application before you thus timely? So let me speak first to the duplication issue, which has been raised and raised and raised. So when Mr. Toto was representing the Woos prior to my involvement, as I had indicated to the board and we had discussed, the facts and the landscape surrounding this application were very different. And there was a code prosecution that had just started. And when that application was ultimately withdrawn in June of last year, there were issues that were raised by the Stanciu's attorney, some of which went to the procedural components of whether it was timely or not, whether there was an appealable decision, and the issues are in those meeting minutes, and the board is well aware of it. So Mr. Tota at that time withdrew the application. The board acknowledged the withdrawal. There wasn't a decision. There was nothing rendered or done on the merits that evening. Application was withdrawn. So is that the same application that you're hearing tonight? If you start on point 2 of the memo of law that I've sent to you all, I'll break it down. The issue is just, is this the same application? Have things changed? And let me tell you why things have changed. It's very clear. Since that application was withdrawn, I appeared in front of Judge Timone and settled the code violations that were outstanding, that were relating to the 2 encroachments into the side yard. I provided a copy of that stipulation of settlement, which is in your packet. And in that stipulation, in that stipulation, I should say, it says, do these things before 1 year from tonight. That 1 year hasn't elapsed yet, but the Woos have undertaken almost all of that work to restore the violations, bring all the encroachments off the property. I've made 4 requests of opposing counsel to go on and take out those fence posts that were cut by the Stancius and left in the ground. They haven't been acknowledged. They've been acknowledged, but they haven't been answered. That's the only thing that remains in satisfying the stipulated terms of that code violation prosecution. They did everything probably within a month of that thing being approved. So with that background, once we had settled that code violation in court here, the issue then what was the decision? Is there a decision that could be appealed to this board? And at that time, there was not. So you'll also see in your materials a submission to Supreme Court Westchester, and that's number 5, where my office in September, October had brought an application to ostensibly force Tom to make a decision on our pool C of O, which hadn't been decided. It obviously hadn't been approved, but it hadn't been denied. So what is the change between the prior withdrawn application and this one? Number 1, settling that code violation prosecution. Those encroachments no longer exist as far as I know. As far as I know, I think those fence posts were even removed within the past week by the Stancius, but I'm not certain of that. So that's number 1. Number 2 is that as a result of this litigation in Supreme Court Westchester, Tom Puma issued a decision dated October 25th, 2022, in which he denied the C of O for the pool, which we appealed within 60 days on December 23rd, when I sat in Tom's office and handed him the application with the stamped page that I held up for you at the last meeting. We then amended that application to add a little bit more detail in terms of the surveys, the engineering details, which showed above and below ground, all the encroachments were gone. So that's where we are today. That's the material change, or 2 changes significantly between the first withdrawn application, which was never decided, and which I have in front of you today. So it is a materially different application. It's based on a decision that Tom had made. That's why we're here. As to the timing of it, it's pretty simple math. 60 days from October 25th and 12/23, we're under that 60 days. So that's the submission on timing and whether it's a duplicate application. So if the board has any questions on any of that, I'm happy to answer it.
Any questions right now?
The original violation, right, was for the encroachments and the setback.
The violations were for, and I can pull them here.
September 3rd, 2021.
Yeah, let me just read from the 21 notice of violation letter for you. The first violation was it appears the swimming pool barrier, meaning the fence and retaining wall, were located on the Stancy property or the neighboring property. And as you had said, Mr. Newman, the 15-yard side yard setback wasn't met by the
Okay.
location of the pool.
So at that decision of the building inspector, would that not then give 60 days from September 3rd, 2021 to apply for a variance on that setback violation?
Well, with the pending code enforcement action that resulted after that.
That first court appearance wasn't until February of the following year.
Right.
So there was nothing preventing a variance being requested in that, once that violation was issued, correct?
Correct.
I'm sorry, who was that?
That's Whitney Singleton for the stance use. That's a correct statement of law.
Yeah.
Can I finish?
Mr. Singleton, yeah, please, we'll give you an opportunity to speak, but we're just hearing from Mr. Caruso right now.
So the position that we take is that the notice of violation letter indicated that further legal proceedings would result if action wasn't taken to remove the violations. Now, I'm sure that Mr. Singleton will tell you that that could have been an area variance that was applied for at that time. Another way to go about resolving those was to remove the encroachments or, and that was something that was being discussed and worked out between the neighbors at the time. So one thing that's not very apparent in this record, which Mr. Toda's affidavit actually identifies, is that there were a lot of negotiations going on between the Stancius, Jerry Riley, and my clients and Mr. Toda about how to privately resolve this before availing themselves of the zoning board. That's what took so much time. So, Mr. Newman, it was not a clear path. And Mr. Toda went on quite some length about this. There was a lot of encouragement, and I wasn't present for this, but my understanding of Mr. Toda's affirmation states there was a lot of encouragement to resolve this outside the context of the zoning board.
In the court proceedings, in the course of the court proceedings, which started in February of next
prior
year?
to that, in 2021. So there was a lot of activity between Mr. Riley's office, I understand, Mr. Singleton, Mr. Toda, or at least Mr. Riley telling them, I believe, to work this out. And I do believe they made a lot of efforts towards doing that. They didn't end up with a result that either party was happy with. Now, did that land beyond the 60 days? Certainly. I'm not here to deny that. But the question is the application I have before you tonight timely? It is a decision of the building inspector. And your code says within 60 days, I can appeal any decision of the building inspector. That's what we did.
And the notice of violation is now settled.
That was settled through the court process, through the stipulation that's in the record.
Including the setback violation.
The violation, notice of violation is settled. That doesn't mean that
It's not
that
been remedied.
within that notice was completed. But it's no one an open notice.
My clients received a conditional discharge in that code enforcement case. So, Mr. Newman, with those two issues, what the court did was it said, fix the encroachments within a year, get what relief you may or may not need from this board. And at the conclusion of that time frame, your discharge would be conditioned on removing those encroachments first. And if I'm not mistaken, I'd have to look at the record a little closer, but I don't recall whether Mr. Riley actually withdrew the setback violation, and my clients pled guilty to the first encroachment and the first charge with the encroachments themselves. I believe that's how it happened. I can inform the board. So whether that is an active violation, the setback issue, regardless of how it was pled out, they were both resolved in that stipulation conclusively. So the year hasn't expired yet. We're still within that amelioration time frame to get all those encroachments out. And we've worked very quickly to do that.
can I interject, or is this, it's gonna go on?
Yeah,
Because you're covering a lot of
wait.
issues, you're covering a lot of issues which could be very easily disposed of. Mr. Caruso just said the court said go to the zoning board. I can show you the disposition of the case. It said nothing about going to the zoning board.
Well, why don't we, if we're done here, let's officially, we'll come over to you.
Yeah.
Okay.
Well, forgive me, I may have misspoken on that point. The court didn't say expressly go to the zoning board. Part of the conditional discharge was fix the encroachments within a year. If you need more time, apply to the court for more time. Mr. Singleton's correct. It wasn't that they said go to the zoning board, but both of these violations were resolved in that conditional discharge. So there was no remedy in that sense to the zoning board. We couldn't go to the zoning board at that point in time because those violations in 2021 were resolved in that court proceeding. So that's the bookend to that, if you will.
Okay.
Thank you.
Any further comments to Mr. Caruso at this time? Discussions?
Let's let Mr. Singleton.
Okay, so then, okay, so, yeah, I think it's the opportunity. All right, so Mr. Singleton, we'd like to hear what you have to say. We did receive a submission from you, that unfortunately only came in, I believe, I saw it the first time today, so, yeah.
Yeah.
So-
There's a couple of dispositive things in there. But I will try to, I'll try to focus on the issues before your board that were discussed by Mr. Caruso. Years ago, they were issued a notice of violation. They did not timely appeal that notice of violation. They were untimely in appealing it. Your minutes will reflect that your board determined, unlike what Mr. Caruso said, your minutes reflect that your board determined that the application was untimely. They cannot, as a matter of law, renew an untimely application by making a subsequent application for essentially the same relief. Whether they wish to couch it as now a application or appeal of a denial of a certificate of occupancy or resubmitting the same application is of no consequence. It's the same exact thing. They are seeking the same identical relief that they sought back in 2021. More importantly, with regard to the timeliness of this, one of the things that seems to be overlooked was the building permit was issued in 2019. Under your code, a building permit can only be issued for a year, and after that, it is expired. You can't submit an application for a certificate of occupancy for an expired permit. Your board has a statutory, not authority, but obligation to render a decision which should have been rendered by the building inspector in the first place. He should have denied, as he did, the application for not complying with the setbacks, but he also should have denied the application because there was no longer a valid building permit. Your board, pursuant to state law, which is in my memorandum, mandates that you substitute your determination for that of the building inspector, which should have been made in the first place. If the building permit was expired and was not renewed, and it couldn't be renewed because it was already determined that they were in the setback. If the building permit had been expired, they cannot apply to the building inspector for a certificate of occupancy, and your board can't bootstrap their CO application to renew an already untimely application from 2021.
Mr. Singleton, just a quick question.
Sure.
I understood that the earlier application was withdrawn, and I thought once it's withdrawn, it's a legal nullity, but you're saying that we need to heed that earlier application. What am I
Yes,
missing?
your minutes show that it was untimely. Your board determined that it was untimely for the simple reason that it was untimely. Second,
I think it was untimely, but he withdrew it before we made any determination.
He withdrew the variance application.
but he was already time
Board had
barred at that
discussion
point.
that we couldn't hear it because it was untimely, at which point I believe they were looking first for the interpretation on timeliness. And then if it were to be determined timely, that they would then
Did we have a vote?
also application.
There was no vote. No, there was no.
Your board made a determination and your minutes reflect that. So you should check your minutes. I put it in prior correspondence to your board. If you'd like me to cite it, I can. It'll just take me a minute to find.
It's a question. My recollection was that the application was withdrawn. And that it therefore, this is a new determination. So this is an appeal of a new determination. I understand your point, Mr. Singleton, with the similarities on the setbacks and why you believe it's not materially different. But if the first application wasn't heard, that's my question.
All right. So assume for a second that your board did not determine that it was untimely, which you did. Let's assume for a second that that's not the case. The fact of the matter is that an applicant has a statutory procedural process that they can go through to preserve their rights. If somebody is issued a determination by the building inspector, which they wish to challenge, there is a provision that they can appeal to your board within a statutory period of time, and that stays all prosecutions before the court. That is not what happened here. They never made an application for a stay. They pled guilty in the court to the violations, including the setback violation. And your board, whether you made a determination or you didn't make a determination, the period within which to challenge the building inspector's determination had statutorily expired. It cannot be extended by your board. You have no authority to extend it. The fact that you're going to turn around and say, okay, well, the building permit applicant or the violation, the notice of violation and our ability to challenge that expired. And by the way, we pled guilty. But now what we're going to do is make an application for a C of O based upon the same exact building permit. That is trying to renew a permit for the identical relief. And the courts are on to that. They have said that you cannot do it. You may not submit successive applications for what is essentially identical relief. The cases are replete in that regard. And they're all, I've cited several cases that stand for that proposition. So what would prevent the woos from simply submitting another application, getting another denial and appealing to your board? The point is there's supposed to be a period of repose for the neighbors. The stance you shouldn't have to be here years later fighting the same issue, which was done as a direct result of errors and incompetence and perhaps deliberate actions of the woos and improper actions by the town. The town should have gone out and had the survey markings verified before any foundation was poured. That's standard operating procedure. The fact of the matter is this is an untimely application. Mr. Caruso is trying to bootstrap it. I was promised by the several attorneys that have represented the woos now that no application would be made to the zoning board because they wish to either buy land from us or get an easement from us or work out some sort of resolution. And I said, that's fine. They asked me to draft something. I drafted something. They asked me to draft another agreement. I drafted. I said, the only condition we're willing to work with you to make sure that this application does not have a deleterious impact on my clients, so long as you don't make any applications to the zoning board until we have a stipulation of settlement. And what happened? Mr. Caruso submitted another application, didn't tell us, and just gave me lip service, not identifying any of this having been going on. So I respectfully state that Mr. Caruso is selling you a bill of goods. The application is time barred. It was time barred in 2022. It's time barred now. And even his most recent submission doesn't even meet the 60-day timeline. He tried to submit in December 23rd, which was the last day to submit on, and he withdrew it. He physically removed it from the building department's office.
Excuse me. I can't let this go on.
Well, I was having my opportunity to speak.
Forgive me. I sat in December
Why don't
20.
we gave you an opportunity to finish. We stopped Mr. Singleton from interrupting. And the board may decide that we'll have each of you speak again, but I don't think anyone wants to do a back and forth tonight.
Yeah, let
Let's
Mr.
not.
Singleton finish, and then Mr. Crusoe, we will definitely go back to you. Okay.
Gotcha.
All right. Mr. Singleton, any further
Chairman
comments?
Canestra, if I go to file a tax return, and then I decide, you know what, I don't want to file it on April 18th or April 15th, and I decide not to do it, and I say, IRS, give me my tax return back. And they give it back to me. Have I timely filed? Of course not. I took it back from
What does this
entity that
have
I
to
was
do with
making-
this application?
Of course it does. You physically took the entire application back from the building department and submitted a new one on February 1st. That was 90 days late.
All right, so let's go to Mr. Caruso now. I'm going to give each of you another opportunity before we take it out to the public. I want to see what anybody else has to say in regard to this. So
I'm sorry to interrupt, Mr. Chairman. So forgive me. I can't tolerate, and I teach my children the same thing, which is you don't stand here and let someone just tell a flat lie. And I'm not going to let the board listen to that. I sat in Tom's office December 23rd with the application I filed for my clients as an officer of the court. In his office, he took it from my hands, he stamped it. I showed you the page. I have the page. I never went back to the office and physically withdrew an application. I have no idea what this gentleman is talking about. I then amended the application in February, which the board has. First one was copy filed. Second one was copy filed. I don't know where his imagination is taking him, but I
Okay,
can't.
let me address that. I had specifically requested of your board copies of all submissions. I was told none were made. So clearly it was untimely. So then I found out before one of your most recent meetings, oh yeah, there was a submission, but we don't have it anymore. Mr. Caruso took it back. Denise is on this call. She couldn't give it to me. I said, can I get a copy of it? She says, we don't have it. He physically took it back. You're welcome to take testimony from your planning board, zoning board secretary. I have the emails where this was told to us. We couldn't understand why we couldn't get a copy of a submission to a public agency such as the zoning board. And then we were told that it was physically removed from the office, that Denise had requested that Mr. Caruso return it, and he eventually returned it, and it was eventually supplied to us. But you did not have it in your office.
There's a very simple answer to this.
Denise, would you like to comment on that, Denise?
I would like to comment when the chairman asked me to comment, if you don't mind.
Yeah, I
Thank you,
don't think we
Whitney.
need to have it back and forth bickering here. All right.
And I don't think this is our primary issue.
No, it's
I'm
not
not
the
going to waste
primary
the board's
issue.
time with
Yeah,
it. It's frankly ridiculous. I'm not going to waste the board's time with it.
We're kind of going off on a tangent here, so.
Well,
Okay.
to get the board back on track for a moment here, my recollection of reviewing the board's June 2022 meeting minutes and the video was that there were no findings made. There was no determination made, no roll call, no vote, period, end of story. Application withdrawn. I agree with Mr. Lansky. It was a legal nullity. Nothing happened. There's no administrative record that would bind us tonight, other than the fact that there was an application that was withdrawn. Period, the end. As far as the building permit expiring, there's a renewed copy in the submission that we have. So that was renewed. So we're here with a building permit that's in effect. The building inspector hasn't rejected our submission or said, I'm not considering anything because you have an expired permit. There may have been reasons why the permit was left for a little while longer due to COVID. I have no idea. The permit is renewed in effect as we stand here tonight. Again, another issue, which is very simple.
That issue's not before us anyway.
No.
So.
Well, Mr. Singleton has been trying to make the point that there wasn't a
He's saying
valid
we need
early
to bring it up, but it's not before us.
Would you like me to read you your minutes? I can read you your minutes. There was a question brought before the board as to whether or not the application was timely before them. After a lengthy discussion with comment, All of the members agreed it was not.
But that
That's
doesn't
what
mean-
your board states. That's what your official minutes state.
But that's not a determination of the board. The
That's-
board didn't
Of course
vote.
it is.
That was our opinion, that was our consensus, but we did not vote on that because they saw the way that we were leaning toward voting, they withdrew.
No, ma'am, I'll let you speak if you'd like, but.
Right. So any applicant upon hearing conversation amongst the board that thought that their application were to be denied could immediately withdraw and resubmit later.
Well,
I mean,
There's,
Assuming they were timely. So Mr. Newman, listen, when when you're dealing with lawyers, it's a good question because that could be well abused, right? So for example, if that application were withdrawn and it was the identical application and was just resubmitted, well, you'd have a timing problem because that 60-day clock would run. So how would you get around that? Well, the answer is not to tease out some other ministerial decision or some other loophole to get back here. And I'm sure that, well, I'm not going to speculate. Regardless of that, if there are people that do that and that's a technique that's used in other boards, so be it. It's not here in front of this board. There was another determination that was reached. It came about through separate litigation. October 25th, it hit. We appealed it. Again, it's simple math.
yeah, right.
But that appeal is for the identical relief sought in the already time barred application.
So again, back to 2021, to just wrap this up from the applicant's standpoint. The 2021 notice of violation has to be considered with the code violation prosecution in the Justice Court before Judge Timone. That folded into it. The disposition was reached. The court so ordered it. The woos have acted on it. And there is still time to finish whatever encroachment work that needs to be finished. I don't believe there is any. I think it's all gone. They can speak to that. That's 2021. So we're here based on that October 25th, 2022 determination. Your code says any determination of the code enforcement officer can be appealed.
Mr. Caruso, does a justice court determination or so ordered settlement extend the limitations period before this board?
Mr. Singleton, I'm not here to answer that question.
Well, because the answer is no. If it was time barred in 2022, it's time barred in 2023. The fact that you submitted another application for the same relief does not restart the clock. That is basic zoning law.
discharged. It no longer, once it's either pending discharge or it's discharged, it's no longer exists once it's discharged. And so you have to start with a new determination.
And we got one.
And so there's a new, and I understand your point of the similarities between the applications. The pool's the pool. We all get that. But you're arguing technicalities instead.
No, I'm not. Neither your board nor Mr. Caruso nor Judge Timone has the ability to extend state timing deadlines.
We're not saying he did.
The application was untimely in 2022. It can't be timely now. What the judge did is irrelevant to your board's proceedings. Irrelevant. They can't even be considered.
It goes back to my original question. The original violation or the setback was September 3rd, 2021.
Yeah.
No variance or appeal was filed within 60 days of that.
Okay, but
Correct.
And that's fair, but that determination is now pending discharge.
No, it's irrelevant.
No, listen, the violations in 2021 were a decision by the town to prosecute. They issued from the building department. They prosecuted the violations. They said, you're in violation. Here are the letters, September 2021. The Justice Court issued there were accusatory instruments that were issued in the Justice Court. The Justice Court then engaged and facilitated that prosecution in court. So those issues, whether they were whether they were from March, April, January of 2021. The culmination of those violations and that decision to prosecute and the resolution in justice court that I witnessed and I was part of with Jerry Riley and Justice Timone, resulting in that stipulation, was the end point of that process, period. The decision that resulted from October 25th, 2022 was a new decision based on new issues that are materially different. And that is why we're here. It's really that simple.
So you're saying substantively, this is a new application and that the judge made a zoning violation go away? That's absolutely absurd. The building inspector made a determination in 2021. It was not timely appealed. The period within which, and forget what the court did, that's irrelevant to what's before this board. You did not make a timely application. You're now trying to bootstrap a 2023 application for a 2021 violation by saying that, oh, the court got rid of the old violation. As far as I can tell, you've been in violation for the past 3 years.
Yeah.
And there's been no remedy.
From my point of view, I've heard enough.
Yeah,
I think I understand both.
Yeah, we're kind of going back and forth and kind of repeating the same material. What I think I'd like to do at this point in time is, I'd like to know if anybody else here wishes to speak in regard to this application, or anybody online wishes to speak in regard to this issue before the board has some further discussion. Anybody here who wishes to speak in regard? Yeah, could you please go, could you give us your name and
Let's not repeat anything.
yeah, I mean, if we've been over material, obviously we don't have to repeat.
That is not.
And what is your name and address? Are you?
My name is Annie Stanciu, and I'm the neighbor living at 4 Silver Springs Court, next to the US property.
Okay.
Mr. Singleton, he made and he provided actually to the board with sustaining and outstanding written letters, professionally written, regarding the illegalities related to this pool from the very beginning, then was start to be built with the timing of the applications to relieve from this board. I want to emphasize that I am present here in the board, not to address any legal issues, because my attorney is doing a very good job. I'm thankful for that. I want to present the hardship of a neighbor that did nothing wrong. And for 2 years, I had to spend time. Tom can say how many times I went to building department. For 2 years, I had to spend money, thousands, tens of thousands of dollars for them wrongdoing, for encroaching my property with the walls, with the fences, with the pipes, with the damaging my properties, making stone walls, the drainage system, it's damaged, my parking lot, my driveway, it's damaged, the trees are falling apart. For what? I'm telling you why. Here is a board. This was all started in 2019. In January of 2019, they had a survey showing clearly what is the property line. At that time, my property was on market for sale. So they figured out the old owner passed away, the property is for sale, new people are coming in, they don't know what is the property line. Now it's our time, so we can take advantage and build a pool that is illegally placed in somebody else's property. So that is the survey was done for them, for Deborah and for Victor Moose in January 2019. They did nothing. They knew where they stand until they wait until September 20th. It's here, I made the timeline. September 20th, 2019, we did a closing. After that, they start excavation the end of September, not before, because they knew maybe a survey would be in place, nothing to go wrong with selling the property. They sell that, they did everything until 2021, when I saw by accidental and 0, they encroach in my property. I told them as a neighbors and I told them, I showed them. I came to talk. I said, we have situation. Let's solve this. Ask them, please, to remove the encroachments in my property. No, they start to fight with us. I had to hire an attorney. I had to hire a survey. I had to come to court for 1 year for them to finally plead guilty to the 2 violations that the building department gave to them for the encroachments, not for the encroachments, but for the wall being in my property and for the pool not being 15 feet away from the property line. So then we are now here. Took them another year, not another year, I'm sorry. After 1 year, took them few months to remove the encroachments. And do you know how look my property now? I'm gonna show you how look my property. With all these that they were cut by us because they refused to do anything, with all the fences, all the way 68 feet in our property. With the pipes sticking out from the ground because they damaged my land and they refused to fix it.
Man, when you were here last,
Okay, 1 second, with the trees falling apart, and you know what? They are not willing to do anything. I have here the plans from the board of from the building department shows clearly the 6-inch PVC had to be rerouted. You know what they did? They cut it, it's sticking out the ground, and they did it around the pool. And my property is getting damaged because this drain that was here, they cut it off to put their pool. You are without words. You know,
No.
I want to just give me a minute and then I'll be done. I want to just you, please, take out from the position you are now and put in my shoes. Go think of your home. Think if somebody will do that to you properly, how you will feel about it. After you try to talk to them, to go the nice way and not to spend so much money, because I'm sure they encounter so many expenses because they have to hire at least 3 lawyers. So then think of your home, somebody is doing that to you. And then come here in the position that we have and the power and the decision that we can make. And then ask yourself, what is the right thing to do?
Yeah, man, the issue before us right now is whether this application is timely before us. So that you're almost kind of talking about issue 2. And, so we've got to try to determine whether we can, we're going to hear this application at all.
Okay.
And then, if we are going to hear it, then we would make a determination as to whether we would grant a variance or not. And then I think a lot of what you're saying is then more relevant to what we're talking,
Okay, I am thankful for your time. I'm sorry that I'm getting very.
We appreciate you coming
because-
before us and, but, we're,
And I want just to make one last point and I'm done. With regardless to what Mr. Caruso, he said that this is unheard what Mr. Singleton said. I want to tell you right now and right here, I was personally in the office of Denise and I was asked her for the application. I asked Tom for the application. They said they don't have it. And Denise, she was telling me that Mr. Caruso came and withdrew the application and he submitted a new one in February, in the beginning of February 1st, I believe. And that is the reason why the application he submitted in December 23rd never was uploaded in the system to be heard by this Board of Appeals, because the application didn't exist, or if it existed, was incomplete and he withdrew it. Once he withdrew it, it's none. The application that was submitted was February 1st, and then was uploaded to the system. And I have Denise on record saying that. So for him to say that is not true and he doesn't know what Mr. Singleton is talking about is just embarrassing.
thank you.
Chairman,
Anybody else?
Can I
Does
make one
anybody
more
else-
point? Can I make one more point related to the the issue.
Oh, yeah, Whitney, well, just give me one more second here. Is there anybody else here who wishes to speak in regard to this application, or let's put it online also?
Part of the application.
Well, this part of it, yes, this part of the application, right? We're really, what I want to hear is issues related to whether this application is timely before us. That's the issue right now at hand. And we have to get through that first. Does anybody else here wish to speak in regard to it? Hi, if you could just give us your name and address.
Hi, I'm Deborah Wu. I live at 8 Silver Springs Court,
Yeah.
Katona, New York. We had the first time for the board. Everything was dismissed. There was nothing settled on, nothing was heard. We didn't do anything. We were trying to communicate with each other to get a settlement together. And then in December, we sat in the parking lot with Mike, and he went in and we got it to Denise in time before the 30 days from the November.
60 days, right?
60 days, I'm sorry, yes. And it was done on time and it is stamped. It is a different application. I don't know. I'm confused as to this legal stuff, but we made sure that we were on time.
Okay,
with this
thank you.
application.
Thank you. Denise, do we have anybody coming online who wishes to speak in regard to this application?
No, Vic.
Okay. Last chance, anyone else wishes to speak in regard to this application?
Yeah, Chairman, I just have one thing relative to timing.
Yes, we have one more individual. Sure, come on. Sir, just give us your name and address.
Jim Nikos. I'm at 42 Fieldstone Drive, Katona, New York. I live across the street from both of them. I really probably can't help with the timeliness element of this, but just for both neighbors, we've lived there for about 20 years. We know the Woos quite well. I highly doubt that they would ever do anything to take advantage of you as a neighbor at all. I don't know why you're looking at me like that with the devilish eyes, but or during the time that the property was for sale, they didn't take advantage of anything like that. They're very nice, warm people that help our community. They collect money from all the neighbors for the security systems. They do things that are, neighborly. So to just add to the character here, I'm surprised this is going on so long, and I'm sorry for the fact that you had some loss to this. I have a couple other opinions on it, but I want to keep it
Thank you.
timely for you.
Thank you.
Appreciate your comments. Thank you. Okay, how does the board want to proceed at this point? Do we want to have some discussion amongst us at this point in time? I'd like to solicit. I mean, yeah, I think,
Chairman, can I just make that one final point? I'll be very brief.
Okay, yeah, I mean, if we could not go over the same material though,
No,
and
I'm going to give you an easy out as to how you can dispose of this right now. If you allow me to share my screen, I can put up the law relative to your board's authority, and we can just read through it.
yeah, I think both sides have provided,
Yeah.
Right.
I think
documentation
Your
regarding
board
this.
is-
I think we're crossing into a threshold where this gentleman is now advising the board on legal issues that it could seek independent counsel for. So I think Mr. Singleton should stop here.
Okay, yeah, I mean, I think we've
That's
heard from
insulting,
both.
Mr. Caruso. That's ridiculous. I
Yeah,
am
no,
allowed
I
to
think
argue
we've-
the law.
Yeah, I think
That's
we've
why
heard
we're
enough
here.
from both sides right now. I mean,
They
I
both made their statements.
yeah, I think both.
And we have a fairly thorough.
Yes, we have quite a bit of documentation here. Each side has provided their points. So, how does the board want to proceed?
I would like to move forward
Okay.
with this project, with this.
Okay, so I mean, we should probably have a discussion. I'd like to get everybody's opinion on how we'd like to proceed here. I mean, we can make a decision. We can still go to council if we feel we want to do that.
I would like to see this decided on the merits rather than on more procedural issues. I think that an attorney's affirmation and a client's sworn statement that they submitted it on time resolves that piece of it. And the second piece as to whether or not you know, that first application should have been appealed, or whether or not that's resolved by the justice court, is something we could chew on a little bit. But I land with wanting to hear the application and decided on its merits.
So you're of the opinion that it was timely filed?
I think the Tommy one's the no-brainer. So, but I know there's a couple of nuances, and to the extent we want to flesh them out. That's what we're here for.
Okay.
So, no, I'm good with being sent in a timely manner. I'd like to move forward with this.
Melissa, what do you think? I mean, I can make arguments on either side of this.
Yeah. Right. Same.
I don't mean to put you on the spot, but you know, we can, you know, listen, I'm still prepared to go to council if we want to get some more opinion or more authority regarding zoning matters. If we have to put it off for another month, we'll do that, you know?
Can I strongly encourage that? Because this is a matter of law. This is not a matter of what your preference is.
Well,
I don't care what counsel you get, but this is absurd.
We're having an internal discussion, sir.
yeah, just give it, if they're, let us finish our discussion. You know, I want to hear each board member's opinion, and that may be to make a decision tonight. They may feel one way or another, or they may want to seek legal counsel. I want to hear everybody's position on this.
For me, whether or not the December 23rd submission was timely or not isn't as relevant to me. The initial submission was not timely. And this submission is asking for the exact same relief as the first.
So you feel it's untimely, right?
And but do you have an issue one way or the other with that first one being withdrawn? No vote. Is there?
It wasn't time. I mean,
It wasn't.
whether there was a vote or not,
Decide the first one because it was untimely.
whether procedurally that should have been decided by vote or not, or whether procedurally we don't let people withdraw and we force votes. I think that's procedural. But I believe that the board was about to determine that we were not going to hear that case, at which point it was withdrawn. It was very clear.
Yes.
That was very clear.
We did have an internal.
So we know that original, and I mean, it's obvious from the dates that there was no variance requested within 60 days of the building inspector's determination that the setback was violated. Therefore,
Yeah. So
that's the end. And that's the end. That's the end of my story.
Deal with the next piece of that, with the fact that matter then gets resolved by the justice court stipulation, and it's discharged or pending discharge, and therefore that becomes once something's discharged, it's a legal nullity, and then you have a new determination by the building inspector, which is the subject of this appeal, and this one's timely, and so.
I think there was a new determination by the building inspector, which was refusal of the CO. So a CO was requested that couldn't possibly be granted based on the setback. Nothing had been changed from the location of the pool. So an application was made for a CO that could not possibly be approved.
Had to be denied by time.
It's almost like it wasn't a good faith application for a CO.
Correct. It was a way to.
He has a right to.
Exactly.
Apply.
There's a right to apply, but
But the question, I guess, is the other things which happen in that interim period, meaning the removal of encumbrances, the settling of the justice court, does that change it for you?
I'm two separate things in my mind. Yes, the encroachment was a violation. The encroachment needed to be resolved. It was resolved. That was probably the bulk of the justice court case.
They're clear
Right.
violations.
But that doesn't take away the fact that there's still the main issue of this setback encroachment, which exists today and existed on day one. For me, even if we get past the timing and whether we say we allow it or we don't, I'm not gonna get too materially different between these applications.
Right, so, right, so I mean, the second one, if the December 3rd, 20 submission holds, it was timely. That's not my debate, that's not my dispute. My dispute is it's the same application that was not made in a timely manner based on the September 3rd, 2021 violation determination.
I'm tired of listening to the whole thing, to tell you the truth. The fact remains, the pool is too close to the property line. That's what we've been arguing about here for months now.
Well, even if we agree to hear this matter, then the determination still has to be made as to whether we would grant the variance. And,
Yeah.
it's a significant variance that,
It's timely as far as I'm concerned. I think that the December thing took place. I'm satisfied. I saw the paper. So it's timely. Now, if we're going to talk about the
we've got to decide
encroachment,
timely issue first.
well, okay,
Before we
as
get
far
to
as
that.
timely is concerned, I'm saying it's timely.
I lean on hearing the actual application on the merits. And, we've all internally, to some extent, expressed opinions on that. But I always lean on hearing on things on the merits.
Well, what does that mean, though?
I'd rather be looking at the area variance than worrying about this piece.
And I wish that original variance application had been submitted within 60 days of September 3rd, 2021. I would love to hear this on the merits, but I don't believe I can.
Because you think it's time barred, right?
But he thinks it's time barred because it's the same application. He doesn't find it to be materially different from the earlier application. That's fair, Tom?
Yeah.
And Melissa is trending that way as well.
Yeah.
Now, keep in mind too, we're a 7-member board. One way or another, we got to get 4 votes. We only got 6 of us here tonight. I could see us being 3-3, so I mean, I don't know how things are going to vote, I don't know how things are going to fall out.
Well,
But
I
look,
think we're ready.
it's a complicated matter.
Yeah.
I mean, I've read through all this, I spent a lot of time going through all this, quite voluminous material. I am still of the inclination, I would like to go to outside counsel. I would like to get another opinion from someone who specializes in zoning matters and zoning law. And that's the way I would go. I know other members of the board really want to vote on this tonight.
I think we've heard enough.
Would you ask the outside counsel to make a determination about timeliness?
That would be whether this matter is time barred. If they say it's, we have seeked legal counsel before and not necessarily always gone with it. I like to hear the arguments on both sides from counsel to advise us, what's the arguments pro and con of this. But if it's time barred, then we're done hearing this. If it's not time barred, then we have to hear the variance matter and whether we would grant the variance or not. And the variance may be for some considered to be significant because it's certainly in the 15-foot setback most of the way to the property line.
So
Chairman, can I just point out one other thing with regard to it? It's not only.
Yeah, please, just give us another minute, then
All right, sure.
So to go to legal counsel, the question would be, what is the material difference? Right, that's what we'd be looking for. So just to pull a line out of here, determining whether material difference exists can be a fact-sensitive inquiry reserved only to the ZBA based on assessing the existence of changed facts or circumstances between applications. So it comes, I don't think we're gonna get a lot more. We might get some cases where boards determine what is a changed circumstance one way or the other. And he might help us parse that. But I see Tom's face, and I know that he doesn't believe this to be a changed circumstance, no matter what case. The attorney, some attorney gives us advice on. And I think we all have an opinion on that already. And it's really what happened over that period of time, whether the circumstances were changed. Does it matter that they went and removed the encumbrances, that there was litigation, or all those things amount to a change in circumstance? Or is it basically that the pool is in the wrong place and nothing else matters? Because that's the substance of this issue. And so that's what this boils down to on materially different, in my opinion. And I think we all have our opinions already. At least I know 1, 2, 3 of us do. Right? I mean, I don't know if Arnie or Bill, if you guys are gonna change based upon.
I would like to move forward with this. I believe it was presented to us with the evidence to Tom that it was in a timely manner. So, if I had a vote, I'd like to move forward and hear the main causes, because I have some questions to ask Tom. So this way, I can decide which way to go, whether or not to approve or denial side yard variance.
So I think we should have a vote. We should make a motion one way or the other and vote it.
Well, we're not going to vote on what Arnie's talking about. We're voting on timely.
No, we're just going to vote on whether the application
Whether
before
the application was
is
timely.
timely or not.
That's what we're voting on.
Yep.
That's correct. But if I spoke out of line, I apologize.
No,
No, we're,
don't apologize.
yes, it's a two-step process.
And we don't think we need to hear anything as to the issue of whether the application was removed.
Application was what?
Removed after that
Removed.
December
We
23rd.
can ask Denise and Tom if you want to hear more about that.
I would like to know.
Okay. So, Vic, you want to ask Denise?
Yeah, well, Denise and Tom, I mean, do you feel that the application was withdrawn or removed?
I'd like to comment on that. I
Okay.
know that when Mike Caruso came into the office on December 23rd, I took the day off because it was 2 days before Christmas. And I told him, that he had to bring everything into the building department. And he evidently sat down with Tom. And the applications were stamped in and left on my desk. And then at that point, I told Mike, when I spoke to him and I knew he was coming into the office, that, he did not make the deadline for the January agenda, but I would be placing the application on the February agenda. I can't give you a date at this point because it was the holidays. I decided to retire. They wouldn't let me retire. They wanted to keep me on part-time. There was a lot personally going on between that time and January 11th, when I did finally retire and accepted a part-time job. However, Mike did, say to me at some point, listen, I need to amend this application. I'm adding the engineer information, which was not in the December application. I said, fine. And I did not see that as a withdrawal. And if you look at the application from December 23rd, and you look at the application from February 1st, whatever that date was, it's just stuff was added to it. The application itself did not change. I think the wording was exactly what it was. And I said to Mike, fine. I said, just give me the, updated application. I'm an early bird. I get there at 4 a.m. He and I met very early the day that it was due. And he handed me 8 new packets. And I said, here, take 7 new packets or the 8 old packets. I don't have room for them. And I'm not going to be submitting them to the board members because I now have this amended application. I mean, I think like we're splitting hairs here. It was not withdrawn. It was just replaced with this new updated application. And all that was added to it. It was added to it, had additional information, the results of the engineer reports that the WUs had done. So that's what I can tell you.
Thank you. Tom, did you want to add anything to this, or is that any comments you had in regard to this?
All I did was accept the application and stamp it in Denise's absence that day. I did not review the application. I did not know that what she just said transpired.
Okay.
And so that's about it.
But isn't that the normal process? Isn't that how you submit an application?
To
Well-
drop,
No, to get it stamped by you.
no, it gets stamped in by the zoning secretary. I'm not
It-
reviewing that. That goes to the board members through the zoning secretary.
You know, that particular day, Tom, I think you were the zoning secretary. I'm not demoting you.
I was down another secretary too. So I was doing like plumbing secretarial stuff. as
Take it over
well.
whatever has to be done.
Yeah.
Yeah, I don't think there's any debate that there was something handed in on December 23rd. It was
Yeah, it
stamped
was stamped and, yeah.
and
Yeah, I don't think that's an issue.
amended.
I
Yeah,
want to make
yeah.
a point.
Yeah, no, we're still discussing. I'm sorry.
Oh, you're still discussing.
I'm,
Okay.
I'm sorry. We're still discussing. Yeah.
So for me, I'm ready for somebody to make a motion and for us to try to resolve this first leg of our journey.
What does everybody else think? You want to vote on this matter, or do you want to go to council?
I'd like to vote.
Yeah, I'm ready to vote.
I'm prepared to vote.
Okay. Okay, who would like to make a motion? Whether the.
Hang on, sorry. My
Okay.
computer was dying. Okay, go ahead.
So let's discuss the motion for a second. Because this is nuanced, right? There was the second application on December 23rd was submitted within 60 days of the CO.
Yes.
Of the CO denial.
We're not voting that.
Couldn't we just
It
vote
was-
to hear the area variance application?
That's what that's what I was getting to.
Yeah,
Or
sorry.
whether it's timely properly before.
Well, but
You got to decide whether it's timely.
It's a combination of timely and
it's
materially
properly.
different.
I was just trying to
Right.
Okay.
skirt some of the phrasing, but we can front it.
So I think some people may be voting based on a slightly different, you know what I'm saying?
Yeah.
Well, we're just gonna make the application that. Right now, we're just deciding that this December 23rd is timely submitted. And that's gonna allow it to go forward.
That's how I'm understanding it.
And then we're gonna have another vote on whether
That's how he just described.
whether or not it was materially the same.
And then a separate vote, or no, we're gonna combine them into one.
Why not combine them, right? Because one way or another, it both have to be
Yeah.
affirmative or negative, right? They go together because at the one.
Now you're breaking it up into three parts. We don't want that. Leave it with two parts.
Yeah, fair enough.
We're having trouble enough with two parts.
I think we're
So-
voting on whether the application is properly before us, which means it has to be timely. And it has to be,
Can we just vote
unique,
that it's properly before us? One way or the other. That's not, I mean, that's an internal question.
I suppose
That's not a question to the public. Yeah, we're debating amongst ourselves how to proceed. Yes.
I mean, it could be worded to say that, depending on who was to make the motion, that despite the December 23rd application being submitted within 60 days of the declined C of O, it was materially the same as the original untimely variance submission in 2022.
I mean, do we have to get into that detail? Can't we just say
I
whether
don't
the
know.
matter is timely before us and is,
We can do it either way.
I don't know that we have to pigeonhole ourselves into a reason.
But we can do Tom's language and then it could just be reversed if the vote doesn't go that way. Right? So it's either materially same or materially different. If you want to do it that way, or we could just vote to.
No, it's either time.
It's gotta be
or
both.
It's not time.
That the matter is timely before us and not materially different.
Yeah, they keep it just timely.
Now, wait, if you say it's timely and then not materially different,
You can't, you're
then
arguing.
that's a denial that would not
Timely
hear the application.
Yeah, that's what she.
Right,
Correct.
which may be,
That's what she's
that's,
proffering. And she can make that motion. And we vote on that motion, and then if that one doesn't pass, then we make another motion.
okay, so Melissa, you're gonna make a motion. Are you gonna make you're gonna make this motion? I gotta.
Melissa,
No.
please.
Well,
If
you're just saying that could be the motion.
Yes.
That could be, not necessarily are making the motions.
She's gonna make that motion and we'll have a vote.
Well, maybe she may not want to. She may be just,
Whoever makes the vote motion has to please speak
yeah, we'll speak
Slowly.
clearly and loudly. Yes.
clear and slow.
Okay.
I will move that the documentation was presented in a timely manner.
A second.
Now,
Wait.
wait.
So boots, right?
Wait. We're talking about timeliness.
Yeah.
Okay. I mean, it's not time barred and it's materially the same.
So he just.
I mean, or materially different,
I
or
didn't
materially
say that.
different. Okay.
He just moved that it was time and it was second.
Right.
Let's do.
Okay. You can make a
We
motion.
can keep going.
Okay, so
Can we clarify which application? So you're saying that.
December 23rd.
well, no, the application before.
The application.
The
Before us,
application.
the application before us is timely. The reason you may have behind that, why it's timely, I guess could differ, but
Okay.
it's either timely or it's
Yeah, okay,
not.
I'm good.
So Bill has made a motion that the application before us is timely. Okay, so that's Bill's motion, right? I don't want to put words in your mouth.
Right, that's it.
Right. All right. So Bill is making just that specific motion, not that it's materially different, just that it's timely.
Yep.
Okay, so that's his motion. Do we have a second?
Aye.
Arnie seconds it. That's the motion before us. Okay, Denise?
Roll call.
Yep, hang on one second.
Yeah, take your time. We're just making a motion that the application is timely before us.
Okay. Melissa, I'm sorry, Ms. DiPolito.
Aye.
Hold on one second. I'm sorry. I usually use a different pad of paper.
Take your time. We're taking our time.
And I'm a little tired, but that's okay. All righty, Miss DiPolito, aye. Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Chairman Canestra.
Aye. Okay, so we've determined that the motion is timely before us. So then I guess the second issue, if we want to discuss it, will be, is the application materially different? And that we can hear the matter, because if we don't consider it to be materially different, then we can't hear the matter, right? Because it has to be a unique application. You can't come back to the board with the same application multiple times.
Well, by definition, they did not come back to the board with the same application because the first application was for a side variance. Second application was for a C of O.
No.
I mean, I don't know.
Well, their argument
Is that they're here on two different determinations. So this one stemming from an application for a CO and the other one, but the question is, materially different, whether or not the underlying
Right.
facts, for
The
you.
facts haven't changed.
The facts
The
haven't
pool is still where it was.
Yeah, well, so that's,
That's the
there
question.
are cases which go both ways. And it's a determination of the board, I think, which prevails, how you feel, whether it's materially different. I think that things have changed, and I'd like to hear the application, so I'd like to make a motion that this is a materially different application.
Are you going to let us present on this, Chairman? We were discussing the timeliness of the application. Mr. Lansky's now going off on a tangent that was not presented by the applicants. This is an application for a 100% variance. As your other member pointed out.
Well, the matter is whether it's timely and properly before us.
Right, but
Yeah,
there's
and,
separate issues.
if we determine,
We're not back open to the public.
yeah,
Right, but you said we were going to take these one issue at a time.
We're doing that.
And
Right, but you're not letting me present on it. It's a 15-foot variance before, it's a 15-foot variance now. As you
we're
stated,
not-
the pool hasn't moved. How is the application different? What happened?
We've
what
already,
happens?
can you,
We've heard
Mr.
heard that argument.
When we started, I was trying to break it down to 1, 2, and 3. And
Correct.
then Mr. Russo presented, and he put 1 and 2 together. And then you responded to 1 and 2.
No, I
And so
did not,
I was
I did
going
not
on.
respond. I did not.
both
respond
sides
to
have
the-
responded as to whether this is a materially different application.
Yeah.
That has been discussed ad nauseum,
There
quite
se-
honestly, between the
But
two
there
of you.
seems to be
So
some
I don't
confusion
think,
on your board as to what that means.
no, I don't think so. No, whether the application is different. It's different. You can't, obviously, we understand.
We don't need to keep this.
Yeah.
I think somebody should make a motion. And Tom, if you want to go first and make a motion, or I'll make a motion, I'm good.
Right, because, once again, if the application is not, is the same application, then we can't hear it because, it's the same application. It's already been heard or addressed and we have to move on. So, so there would be,
I would move to hear the application based on the fact that it's materially different. Is there a second?
I'll second.
give Denise a chance to catch up with us.
Okay, Ms. DiPolito.
Nay.
Mr. Gio.
Aye.
Mr. Hardin,
Nay.
Mr. Lansky,
Aye.
Mr. Newman,
Nay.
Chairman Canestra.
Motion before us is whether the application is materially different. And the motion is that you have, Bart, you've made the motion that it is materially different.
Yes, and that we should hear it.
I'll say aye.
That leaves us 3-3.
Motion fails.
Done it to ourselves again.
No, the application,
So we-
as a matter of law, is denied.
We
3-3 vote is a denial before the ZBA.
You know something? I don't believe that's true. I believe, no, wait, no, I don't believe that's true, that it's an automatic denial. I think it can only be a denial if there's 4 against it. So I think,
I'll be happy.
I think
to
it's a
brief you on it.
non-decision is what it comes down to.
Yeah.
My understanding.
We just
Mr.
argued this,
we didn't ask you to
argued
interrupt.
this case. in
Yeah,
the
yeah,
second
yeah,
part.
yes, sorry.
So the vote's 3-3, correct?
That is correct.
That's correct.
But give us a minute.
Thank you.
So, Mr. Padavani will be around. At some point. Right?
Right, we have one more member.
I don't know, Vic, it's up to you what you want to do next.
Well, my understanding has always been you need 4 votes to carry, 4 no votes to deny. We're at a stalemate. So it's basically a push.
Yeah.
I think we should talk to Mr. Padavani. He has all this material. I know he couldn't make the meeting this evening. And I think we'll have to speak to him about it. I mean, members can also review the material once again. We can, review.
So are we interested in adjourning this? Is that what we're saying? Until such time as Mr. Padavani is around? And I'm also interested in encouraging the applicant and their neighbor to get together, which we've all expressed a number of times, that we'd all love to see them resolve it among themselves.
Get it resolved.
I know Bill feels very strongly about that.
Chairman, I can save you a lot of time and aggravation as to your scheduling. The highest court of the state of New York, Tall Trees Construction Corporation versus the Zoning Board of Appeals of Huntington, has determined the effective tie votes by the town of Huntington ZBA for variances. The court held that when there's a quorum of the board present, which you have, and participates on a vote on an application, a vote of less than a majority is deemed a denial. You just denied their application.
Whitney, you're not the board's attorney. You need to stop.
But it is the law.
You need to stop, Whitney.
Well,
We can always seek legal town counsel in regard to this matter.
What's that?
We can seek town counsel in regard to this matter to consult with them. So,
Okay, that, I encouraged that before and I encourage it now, but your board just acted.
Yeah, the vote's done. We can move on.
Yes.
Yeah.
okay, yeah. This matter is
Done.
adjourned for now. We can seek legal counsel regarding that, and then we'll proceed from there.
I thank the board for its thorough consideration.
Okay, thank you. Okay, so we're going to go right back to the agenda. Item 8 is a carryover and postponed. Denise, that of 39 Cypress Lane LLC.
Yes, as far as I know, they have not indicated that they're coming back in front of the board. They may not, but we don't know that yet.
Okay, all right, so we'll leave that alone. Last item on the agenda then would be approval of the meeting minutes of March 28th, 2023. Has everybody had a chance to review them?
Yes.
Yes. Okay, any questions, comments, changes? No. Okay, so I'll just go by a voice consensus. All in favor of approval of the March 28, 23 minutes? Aye. Anyone opposed? No one opposed. Okay, great. I'll make one more note. Our next meeting is third Thursday in May. Denise, you might want to check me. Is that May 16th?
Yes.
Is that correct? So May 16th, right here in the townhouse for our next meeting. Okay,
And Vic, excuse me, if I could just
Sure.
mention, in June, I just want to keep reminding everybody, we're meeting on the second Tuesday, which is June 13th. We cannot meet on the third Tuesday in June because of the grievance day for the assessor, and she needs to be in that room, and and we need to be televised. So we will be meeting June 13th.
Okay, and I do see June 13th is, second Tuesday of the month. I do see that here. Okay, that's great. Thank you for the reminder.
You're welcome.
Okay, so any further matters we need to discuss? Any other issues?
You'll follow up with council just to
Yes,
clarify that vote.
yeah, Denise, I'd like to follow up with town council in regard to this matter.
Yes,
as
you
we
and,
vote.
yep.
So.
Yeah, you and I can talk further about that.
Okay, thank you very much.
You're
Okay,
welcome.
everyone, thank you. Good evening. This concludes the meeting for tonight. Okay, thank you.
Good night, everybody.